Welcome to Security Token Stories, brought to you by Security Token Academy, the leading educational platform dedicated to covering and facilitating the security token industry. I'm Derek Director of Strategy at Security Token Academy. Coming up on today's episode, we have Gabriel Shapiro. Gabriel is a corporate and securities attorney in the blockchain space and has published work across a number of security token and securities-related topics, including the tokenization of corporate stock, decentralized autonomous organizations, or DAOs, and the relatively new intersection of securities laws and sufficiently decentralized blockchain networks. In this episode, we chat about all three of these areas, including his recent work on Metacartel Ventures, a new for-profit decentralized autonomous organization. Gabriel, welcome to Security Token Stories.
Thank you.
I've been following your work in the blockchain space for a few years now. To provide some background, you're a blockchain attorney and writer, largely focusing on how our legacy securities laws map to things like tokenization and blockchain networks. And researching for this episode was a lot of fun. I mentioned this to you before the episode started, but I have a whole stack of Gabriel Shapiro articles next to my desk right now. Before we get started, can you introduce yourself in just a few minutes, your background, your career over the last few years, and the general thesis of your work as a blockchain attorney in the space?
Sure. My name is Gabriel Shapiro. I basically I've been a practicing attorney for 10 years, and during the bulk of that time, let's say 7-ish years, I was based in Silicon Valley, doing fairly traditional buy-side technology M&A and financing work for big technology companies based in Silicon Valley for, some of the big like MLaw 10 firms, maybe MLaw 20 somewhere in there as well. So that was my background. I got into blockchain in early 2016 when I first read about Ethereum and saw the word smart contract, and as a lawyer got intrigued by that, although as you know, smart contracts are really neither smart nor contracts. But put that to one side. It was an intriguing idea. I read a lot of Nick Szabo's work. I even went to the first Ethereum meetup I went to. This just shows how much things have changed. Was in early 2016, and it was a talk by Nick Szabo at an Ethereum meetup, which today is sort of unthinkable, right? And he was talking about the DAO pre-DAO hack. So all these things were like amazing to me as a lawyer, and started thinking about the legal issues. Fast forward a few years, the ICO mania happened in 2017, and I'd gotten to know some blockchain companies at the beginning of 2018. Just a few days after getting offered to join the partnership program at Hogan Lovells, I said, you know what, this blockchain stuff is way more interesting than just doing M&A. I'm going to go join what at the time was a consensus spoke called Grid Plus as their chief legal officer, and see how much I can learn and see how much I can do in the blockchain space. So basically ever since early 2018, so a little over 2 years now, I've been, doing blockchain law under some description or other. Some of that ends up being fairly traditional law for blockchain companies, and others ends up being the more exotic type of stuff that I write about, like DAOs and tokenized securities and these sorts of things.
Yeah, and we're going to get into some of that today. So, awesome background. Gabriel, going through your work before the episode, I thought it would be helpful to actually split up the discussion into 3 short parts that you've written about extensively. The first part is security tokens in your paper, Tokenizing Corporate Stock. The second is DAOs, so decentralized autonomous organizations, and your latest DAO initiative that you're helping out with called Metacartel Ventures. And then the third part is token networks and sufficient decentralization. You just wrote a great 4-piece article on this topic. I think it's timely, and it'd be fun to parse this out with the audience. How does that sound?
Sounds great.
Awesome. So let's kick things off with security tokens and your paper, Tokenizing Corporate Capital Stock. This has been one of my favorite long-form pieces on asset tokenization. There's something like 80 citations in there, and you argue through the motivations and potential implementations of tokenization as it relates to corporate capital stock. So Gabriel, what's the quick 30-second background on this paper? Why did you write it? What were you hoping to accomplish? Maybe just kind of walk through the general thesis for the audience.
Sure. So the basic idea was I'm a big fan of public blockchains, and indeed, I think that private blockchains, enterprise blockchains just have very limited utility, in my opinion. So what I wanted to think through is what it looks like to put traditional securities on public blockchains. And I thought that most of the work that had been done on and so I call those sort of tokenized securities, right, as opposed to security tokens. And I thought most of the work that had been done on tokenized securities was very focused on how to do that in the context of like an enterprise blockchain where maybe there'd only be like a few sort of permission nodes, like maybe DTC would be a node, maybe the SEC would be a node, maybe the Delaware Secretary of State would be a node, and then you would essentially use that blockchain as a canonical book entry system for who owns your shares. By contrast with the public blockchain, you don't control the ledger. There could be attacks, there could be reorgs, there could be double spends, whatever, and so. Or there could be hard forks, right? That change the state or that change some of the rules. So you wouldn't want to never want to say that a public blockchain is like your definitive stock ledger. But what you could do is you could say that there are tokens on that blockchain that essentially have the same role as paper stock certificates do in traditional markets, which is that they're vehicles for transferring rights of securities. So that's the nature of the paper is to kind of explain how you can view tokens on a public blockchain as doing the same things that paper stock certificates do in traditional securities markets, and why that is interesting and potentially useful.
In the piece, Gabriel, you argue that there's already numerous ways of representing rights, interests, and assets, including electronically. And you say that, for tokenization to actually be this revolutionary technology, there should be something unique about the blockchain medium that is fundamentally different than what we've been offering previously. And you argue here that the unique value proposition for blockchain securities is asset sovereignty. So my question is, how does improved asset sovereignty that's enabled by using blockchains for security solve some of the problems that exist today around publicly traded stocks, so our public markets, and privately held stocks, so our private markets?
Sure. And you draw exactly the right distinction there. Whenever discussing traditional securities, you should think carefully about public markets and private markets because they tend to be radically different and to have radically different, problems and opportunities, right? So I won't dwell much on the private markets because I actually think the benefits of tokenization of securities are fairly limited and speculative in the private markets. There are some cool things you can do, I think, with, for example, automating a preferred stock liquidation waterfall through a smart contract and things like that. But that's not really, I would say this is more of an enhancement than something that's revolutionary. By contrast, in the public markets, you have a very, very interesting situation because, at least in the US, in the public stock markets, for example, they are already radically decentralized. They're just very, very inefficiently decentralized in a way that creates a lot of rent seeking intermediaries. So, think about something like Apple Inc. and people owning stock in Apple Inc. Most people might think that they have a fairly direct relationship with Apple Inc. because they own its stock, but that's not the case at all. In fact, Apple Inc. may have very little idea who its stockholders are, and even if it wanted to talk to them somehow, it wouldn't always be able to reach them, right? Because really, what you did to get your Apple stock is you brought it from some sort of broker who that has its own sort of internal ledger, and that broker has, directly or indirectly a claim on a stock certificate that Apple Inc. has issued to, a depository company called DTC, or really its partner Seed and Co. So there's this sort of, cascade of promises that flow down from Apple to this, big centralized stockholder to a bunch of broker dealers and other types of intermediaries down to you. And technically, what you have is not really a share of Apple stock, but you have a different type of security called a security entitlement, which is issued by, essentially your broker dealer, and that flows up and ultimately relates to Apple stock in some way. And all along that cascade are middlemen who are holding data that may not be fully secured, who need to get paid in some way ultimately by you, and are therefore, attacking on commissions and other types of hidden costs, who may have their own creditors that may seek to, in some way, take your property, right? Or who may just make errors when something is transferred and their records may not properly reflect that you're the owner instead of the prior owner, and so you could lose out on your appraisal rates in a merger, or you could lose out on a dividend, or these types of things, or the ability to vote. So all of that, I think, is highly ripe for disruption, and it seems to me that a blockchain-based system is the perfect way to disrupt that, because it can remove all these intermediaries, because you no longer need to trust anything but the software, and it could create a much more direct relationship between, say, stockholders and an issuer of stock like Apple Inc.
Yeah, well said. I think these answers are a great platform for our second topic, which is DAOs, so decentralized autonomous organizations. I saw this excellent tweet from Ross Campbell of Open Law the other day. He tweeted, "If you believe that tokenization or modest digitization of assets is inevitable, then getting familiar with ways to make joint decisions over these assets is well worthwhile." And he was really pointing towards DAOs. And I think Ross's tweet runs really nicely with this idea that once we have digitized assets, like tokenized securities that are owned and managed using these trustless record keepers, blockchains, then over the next few years, finding ways to streamline out inefficiencies in the governance process through things like DAOs and decentralized decision making becomes really interesting. So, Gabriel, taking a step back, for those that are just starting to grapple and work through these ideas, what is a DAO and how is a DAO different than just a regular organization on a blockchain? So taking a shareholder owned corp and transplanting the entire thing onto a distributed ledger. What's the difference between something like that, which certainly has benefits, and something like a DAO where there's an even greater amount of potential automation?
The term DAO, or what the term DAO properly refers to, is really somewhat in the eye of the beholder at this point, I would say. It's a term similar to smart contract that's been a bit watered down and is used in casual ways. The origin of the concept was in an essay about decentralized autonomous corporations by a guy named Steve Larimer, and he was actually saying that Bitcoin is a DAC, right? And then Dan Larimer, I think the last name similarity is coincidental, picked up on that and wrote sort of a more general thing on DAX. And then Vitalik Buterin wrote an essay about DAOs, which I guess was meant to be a more generalized concept. And then that resulted in the DAO white paper, which was about smart contracts on Ethereum rather than a fully autonomous, self-contained system. And so it just sort of evolved from there. So in my mind, at this point, DAO basically means any organization that relies in some way on a smart contract or on a blockchain, and has sort of aspirations of doing avant-garde governance. But reasonable minds might differ on what is the appropriate reference point for what a DAO really means.
This is actually probably a great point to talk about the DAO project you're helping out with. You brought it up, Metacartel Ventures, which, from what I understand, departs from the lineage of grant giving DAOs and is one of the first for profit DAOs, which is a pretty big differentiator. Can you talk about the project a bit and the thesis for Metacartel Ventures, both from a DAO construction perspective and some of the design decisions that you were part of, and to kind of help make, and maybe a little bit about how people can join the DAO and leave the DAO and what happens to their interests. I guess maybe some of the high level details about how it works and how you're thinking about it.
Sure. Yeah, this is like my favorite topic right now. So Amin Soleimani, he basically, he and his team, his colleagues, basically set out to sort of revive DAOs sometime, I think, in 2019, late 2018, early 2019, and they invented something called a Moloch DAO. And they had various Philly. I would highly recommend going to the GitHub and reading the full original sort of explanation for what they were trying to do. But essentially, the idea was, hey, we're gonna have a grassroots movement to fund Ethereum protocol development through voluntary contributors who then make collective decision making based on voting about how the pool of funds will be allocated to projects. And it didn't have an entity. It didn't have, I think my guess is really any sort of legal advice or legal structuring around it. And I think that probably was fine because it didn't have a profit intention. It just had this really benevolent intention to foster ecosystem development in Ethereum, right? And it was mostly contributed to by people who were either just huge fanboys of Ethereum or were maybe like ETH whales or had some significant business interest wrapped up in Ethereum protocol development. And that's what they did, right? They pulled a bunch of money together and they donated it to worthy projects so that they could do what they wanted to do. They didn't like take equity in the projects or anything like that. So that's what, in legal terms, I would refer to that as a not-for-profit unincorporated association, right? And so in California and some other states, there are actually very good protections for those, and not a lot of people know about them. But essentially, you can get the same types of limited liability protections as you would if you had like a corporation or something and you were shareholders in that corporation, because states kind of recognize that as a matter of public policy, it's good to foster these nonprofit associations, and that people can't always be expected to follow the formal steps of creating an entity and so forth. Now, the idea with Metacartel Ventures and things like open laws, the LAO, Limited Liability Autonomous Organization, I guess that is what that's supposed to stand for, is to take that same type of software, a smart contract, right? But then pair it with an entity and make it a profit seeking thing, like a venture capital fund on the blockchain, like the original, the DAO, in many ways. So, of course, when you do that, securities laws and other things, now those become implicated. Now you need an entity and so forth. So I'll pause there for 1 second so you can ask any follow-ups. Yeah.
No, this is you're actually reminding me of something I really liked about the Metacartel Ventures white paper. You had this concept you talked about called, I think it was qualified code deference, which I find really fascinating. It's this idea that where I think the legal structure and the technical engineering of this DAO relies half on code and half on law. So the code half is relying heavily on these Moloch smart contract standards that were previously part of the donative DAO, and then also the legal half is this member managed Delaware LLC, which is I think governed by the Grimoire, if I'm pronouncing that correctly, which is essentially the LLC operating agreement.
That's right.
Yeah, maybe you can just kind of walk through the interplay of these two ideas, the code and the law, as you were, helping add value and engineer this thing, and why did thinking about it in this way lead to a stronger technical product and a stronger legal product? Just hearing more about how you're thinking about these two worlds colliding.
Sure. Yeah. So I think qualified code deference is that's the essence of my philosophy about how these things should be approached, right? Because what we have with the Moloch DAO, the brilliant thing about it, I think, is it has this radical right of free exit, which is that anyone any token holder in the DAO, they can, if they don't like what is happening, they can just take their money and leave. Right? They could just quit. They could just get their pro rata share of the assets that are held in the smart contract, and they could just be on their way. This is radically different from a traditional venture capital fund, right? If you want to liquidate your position in a traditional venture capital fund, first of all, typically you just won't be able to do it. There may be some emergency situations in which you can do it, but you can bet that there's going to be formal procedures that have to be followed, and the people who are in control of the fund, are going to have, probably quite a bit of discretion and or opportunity to be influenced by conflicts of interest that run adversely to you, a mere minority limited partner, and so on. And so that is why adding the smart contract piece to this is a good and interesting thing and is not just solutionism, because it enables transparency and enables you to get out anytime you want with whatever you ought to have without needing anyone's permission. And so I think that should be preserved. Right, that is the best minority protection you can have. All the stuff in governance law about fiduciary duties and different standards of review for management's decisions, those things are all premised on a separation between ownership and control, such that there are these powerless minorities. Now, if you respect the software, the minority is not powerless; they can leave at any time. So, what you need to do as a lawyer in that circumstance is you need to say, hey, I don't want anything I put in the legal documents to ever trump that functionality of the smart contract. So I don't want anyone who exits to ever worry about the fact that they may be breaching the limited liability contract by exiting, and they may not really have the money that they thought that they had or that they actually received. They may have to give it back at some point, right? Now it turns out that's not 100% possible because not all law is contract law, but you do want to say sort of that everyone agrees, all the members agree and understand that the smart contract does stuff that's not under the control of the human. And we have all looked at the smart contract and we've all agreed that the stuff it does without the intervention of a human, it's allowed to do, and we're going to respect the results of that. And we're not going to challenge them later. We're not going to say you should when you quit, you shouldn't have been able to quit at that time, etc. So that's the idea of qualified code deference. We defer to the code in most circumstances. Why is it qualified? Well, because there are still laws, right? Like, for example, if the company has a bunch of creditors and making a distribution would make it insolvent, then technically you're never going to be able to waive away by contract the fact that someone may need to have a remedy there against the person who took the money. Or if there's a court order saying, hey, don't take any assets out of the smart contract, and someone did, again, you can't defer to the code in that circumstance. Like, there clearly was something illegal that happened. So that's why it has to be qualified code deference.
Gabriel, in my mind, one of the reasons we rely on small groups of decision makers to run things like nonprofits or corporations, LLCs, businesses, it really comes down to, in my mind, efficiency. So, like, we assign roles and responsibilities to small groups of people so that we can progress much faster than if it took the entire group time to become adequately knowledgeable on every decision point that an organization or business faces. And so proxy voting within DAOs seems to be like the logical answer. But when I think about it this way, proxy voting would seem to dull some of the benefits for using DAOs in the first place. And so I guess my question is, when you're thinking about DAOs, how do you balance the ideals of a flat organization with this idea of efficiency? And what do you think that means for the future of DAOs? Does it mean that there are sub DAOs under one large parent DAO within each large organization or business? Does it mean that DAOs can only be or should only be applied to certain areas? I guess, am I thinking about this challenge correctly? And is this something that teams and projects are thinking about?
Yeah, I think you're absolutely thinking about it correctly, and it is a major challenge. One of some people, the reason why they're interested in DAOs is they think that they can provide more scalable organizations. Right, so the DAO stack model would be a great example of this, where different different kinds of trade-offs are made than in current large-scale organizations like, say, Apple, because there's this transparency, and you can use game theory and so on to keep people more directly involved, but still be doing that in a sort of in a scalable way. So that's one model for DAOs. I would call those like super scalable DAOs, and that's extremely interesting, right? But as you say, it's sort of inherently impersonal, right? Once you have a group of large humans, they're not all going to know who each other are, and so on. And it's also can be challenging from a regulatory point of view, right? Because we have the market protection side of our securities laws is very much based on materiality thresholds, where they say, hey, anything that's sufficiently small is not regulated very much, and anything above that threshold is actually regulated quite highly, right? So, if you have a DAO that's going out and investing in different projects and it has more than 100 members, guess what? You're now an investment company. You have to go register under the Investment Company Act of 1940. So, in my mind, that's a great ambition long term, but there are a lot of legal and regulatory issues around it. I think the model that we have with Metacartel Ventures is more appropriate for doing something right now, right? Because you can keep everyone knowing everyone, kind of like an investment club, which is regulated more lightly. You can uh, 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 you can stay under that Investment Company Act threshold, right? And you can do other things. So to me, that smaller scale is actually ironically a better vehicle for figuring out how to scale these things up ultimately than just going full on right now and trying to just like do a massive public sale of some massive DAO with a bunch of people who have no idea who each other are, and so on and so forth. But I'm glad that people are doing different experiments in different ways, and I think ultimately we'll get to that super scalable model. But I think making that dovetail with the traditional world of law and order is pretty far ahead at this point.
Super, super insightful to hear you to kind of walk through some of that for us. Okay, Gabriel, switching topics. Wrapping up on the last part of this conversation, I want to cover your four-part piece on token networks and sufficient decentralization, which was recently published. Speaking generally, you listed out a number of issues that exist today with this intersection of tokens and open networks. And you mentioned that securities laws in the US may be somewhat to blame for some of this confusion. So, Gabriel, what are some of the existing problems you're seeing with open networks in the token economy today? What is your philosophy for how we might be able to solve some of these problems? And why should the industry really embrace securities laws and stand behind this idea of securities regulations and applying these things to network tokens in the future?
Yeah, sure. So I think, what I mean by saying that I think securities laws created a lot of problems is really that the way people reacted to them created a lot of problems and sort of has made us all stick our heads in the sand and not call a spade, right? The If you go on cryptocurrency forums, if you go, on Telegram, etc., what you see is a bunch of people basically talking about a token as being an investment in something, right? Yeah, there are some people who use some tokens. Even a broken clock is right twice a day, but the vast majority of people want to buy tokens because they see it as an investment. And I think now some people, the way they have reacted to that is say those people are just wrong. They're just stupid and wrong. They think they're buying an investment, but they've either been deceived or they're deceiving themselves. I actually think they are buying an investment. I don't think they're buying a software license. What they are buying is, because Ethereum as a software protocol can be instantiated on any number of networks, right? And I don't think people really care about some random one of the Ethereum test nets when they're buying ETH. What they care about is that ETH is on a particular Ethereum network, and that specific network, for a variety of reasons, is one that has gotten a lot of adoption and use, and where the demand for that form of ETH on that network is likely to increase, and therefore the value of that ETH is likely to go up, and therefore it's likely to be a good investment. So to me, that sounds nothing like buying a product. That sounds nothing like buying really even a commodity of any sort. It really sounds to me like you're buying a quasi equity share in a network. And this sort of goes back to our conversation about DAOs as well, right? Because that original DAC paper painted Bitcoin itself as a DAC, right, and painted BTC as shares of that DAC. And I actually think that that's not far off from true, because basically they are a form of like network shares or network equity. Yes, they have more uses than a share in a corporation would have. People don't use shares in corporations as money, but that's just an accident of history. Back in the day, there used to be company scrip, and you can still find the relevant parts of the Delaware statute authorizing this, where people would use like parts of company shares as being like money. So these things aren't as different as we think. And I think that the fact that people wanted securities regulations not to apply to protocol tokens meant them, that there had to be this sort of schizophrenia where on the one hand, everyone was buying it and intuitively treating it as like a share of network equity, hence the term ICOs, which is like IPOs, et cetera. But on the other hand, whenever they wanted to discuss it in any other context, they wanted to make it sound as least like that as possible for regulatory reasons. So I just think we should accept that they are what they are. They're not products, they're investments, and we should proceed accordingly. And the SEC surprisingly has been very cypherpunk about this and has given us a path to doing that. They've said, hey, when the network is first launched and it's basically controlled by a bunch of people as like basically something very similar to a business, then it's a security, right? Because you have to have an even playing field among businesses. And it seems ridiculous to, just let people arbitrage one particular technology to opt out of a regulatory regime. But however, they recognize that at a certain point, no one, once the network has matured and it's done what it's supposed to, which is be a decentralized sort of common goods, then it no longer implicates the securities laws because there's no information asymmetries the way that's traditional with like a company, and so on. And so the securities laws don't apply at that point. Now, they haven't really given us a clear definition of when that point of maturity is reached. They have said that they think Bitcoin and Ethereum have reached that point, which are good touchstones. So, one of the things I did in that paper was say, hey, here's my idea of like a safe harbor or a test, for when that point should be considered reached. And I hope the SEC adopts something like that to give clarity to the industry. But I do think in any case, they've given us quite a good path that lets us embrace what tokens truly are. Yes, you have to comply early on, and that's expensive and painful. But ultimately, you can get something that is a good, robust public commons, and that doesn't exist in the shadow of a bunch of law breaking at the time of the project launch.
Yeah, that's great. And I have a couple questions here about that safe harbor. I think you called it regulation crypto or Reg C. But before, I just want to walk through the general thesis and you tell me if I've got this right. With network equity, you define it as a token that tends to capture all or a portion of the value of an open network and up through the point of sufficient decentralization, normal securities regulations. So, for example, Section 12 through Section 16 of the Securities Exchange Act of 34, those should apply to these network tokens. And this is a good thing. If this is the case, at what point, do we have indication that this network is sufficiently decentralized? And I think this dovetails nicely with the end of your piece, which you propose this regulation crypto or Reg C. So you touched a little bit on it just now, but maybe you can just kind of describe what that could look like, and if I've got that general thesis correct.
Yeah, you got the thesis. You summarized it very well, probably better than I would have. So the safe harbor I proposed, and again, I didn't pin down every single detail of this, partly because I hope other people will pick up the banner and work on this as well. But the basic idea is this: that there are essentially two thresholds that should be met. One of them is that the original issuer doesn't like control a material percentage of the tokens anymore, right? Because that's just kind of a just from the point of view of incentives, right? Or if you're thinking about like the expectations of a buyer, if I'm going out and I'm buying XRP today, I can look at the fact that there's this company called Ripple that exists, and I can see that Ripple has a bunch of money, right? Has a bunch of people who may also hold XRP managing it, and I can just kind of reasonably expect, just from that circumstance alone, that this company Ripple is going to try to drive value to XRP, and therefore I may be buying XRP on the expectation that that company will do that, and that may satisfy the Howey test and make XRP represent an investment contract. So that's one piece in my mind that's critical, that you have to set some threshold, and I would say maybe it's like under 10%. When the original issuer and its affiliates own less than 10% of the token, then it's no longer as suspicious in that regard. And then the other piece is just that. the original promises that the project were launched with have been fulfilled, right? So those are, again, it's, the reason why protocol tokens may be securities is that they're quote unquote investment contracts. Contracts involve implicit or explicit promises. And so at the time when all the promises involved in that contract have been performed, then the contract no longer exists and people should not have any expectations under it. So if you take those two prongs, one of which is kind of like issuer defined, right? Because the issuer gets to define what promises it makes, particularly if it, embraces this path and decides to be very specific about that. And the objective prong, which relates to what are the objective incentives based on token ownership, and both of those are satisfied, I think at that point, one should be confident that sufficient decentralization has been achieved, and the network is now something that lives on its own. Now, that's my idea for it, right? The SEC has not co-signed that, and no lawmaker, there's no law that directly says that. There's no case that directly says that. But based on the principles of securities laws, I believe that that's a pretty good test, to whatever extent one may be amenable to the idea of creating a clear test for that.
Yeah, that's great. Gabriel, I've really enjoyed this conversation. You've got a ton of knowledge on this stuff, and it's been fun to follow your work and journey around these difficult topics. Where can people learn more about Gabriel Shapiro and the projects you're working on, and how can they reach out to you if they'd like to learn more?
Yeah, right now I'm working on a website, but right now by far the best method is just to find me on Twitter, where I am at Lex, that's Lex _node, NODE, with a purple avatar with like cyberpunk shades. So if you find me on there, I pretty much post all my stuff on there. Some of it's on Medium, but I link to it on Twitter. And then I'll, once I have a better website, I'll be putting that up. And in terms of what I'm working on, I'm a lawyer, right? So I do take clients. So if you have an interesting crypto project and you're not just sort of looking for a criminal defense lawyer before you've committed the crime, but are interested in getting legal advice and following that legal advice, or you're interested in just a transaction like a merger or acquisition or a financing, whether it implicates blockchain stuff or not, I'm always happy to talk to people who are interested in having a lawyer for that.
Awesome. All right, Gabriel, thanks for joining me on Security Token Stories.
Thanks so much, man. Take care.
That's it for this week's episode of Security Token Stories. For more security token content, visit us online at securitytokenacademy.com and subscribe to our newsletter, The Security Token Edge, which lands in your mailbox each weekend. You can also keep up with the latest security token news by following us on Twitter, Telegram, YouTube, Facebook, and Medium. Before we go, a big thank you to Security Token Academy's Platinum and Gold corporate members who make this podcast possible. You can learn more about Security Token Academy's corporate members at securitytokenacademy.com. I'm Derek Edward Schloss. From all of us here at Security Token Academy, thanks for listening.
Security Token Academy does not provide investment or legal advice. We are not a registered broker-dealer or investment advisor. Opinions expressed in this podcast are the speaker's own and do not necessarily reflect the views of Security Token Academy. More information can be found on our website at securitytokenacademy.com.